That's your cue, Holly.
Oh, are we ready? Okay. All right, ladies and gentlemen, warriors for truth and defenders of the American homeowner, welcome to a night that matters. Tonight, we are honored to welcome a man who didn't just study the mortgage industry. He challenged it, he exposed it, and he paid the price for telling the truth. Our guest is Kenneth Trent, JD, which is Juris Doctor, which Tammy had to explain to me. That is the doctoral degree for attorneys. A 17-year foreclosure defense advocate, a whistleblower and mortgage fraud investigator, and one of the very first legal minds to uncover robo-signing fraud long before it became a headline. When the biggest banks were telling the public everything is fine, he was pulling the curtain back. When documents were being forged, assignments fabricated, and homes taken without lawful authority, he was documenting it, naming it, and proving it. In fact, some might say he became Bank of America's worst nightmare, not because he was reckless, but because he was right. He is the founder of Citibank, VD Bank, Untrust and Falsist, and the author of The Banker's Secret, a former MENSA member, and scored in the 96th percentile on his LSATs. But titles aside, what truly defines him is this: he chose truth over comfort, he chose integrity over silence, and he chose justice over approval. Yes, he is a disbarred lawyer, not for harming his clients, not for fraud, but for exposing mortgage industry fraud at a time when very few dared to speak. Tonight, he joins us not as a relic of the past, but as a veteran of the front lines, bringing clarity, experience, and hard-earned wisdom to a system that still depends on confusion to survive. So if you're here because you've been lied to, if you're here because documents didn't add up, and if you're here because you know something is wrong and you're done pretending it isn't, you're in the right place. So help us give a powerful welcome to our guest speaker tonight, Kenneth Trent, JD.
Welcome, Ken. I hope everybody will unmute to say the same.
Welcome, Kenneth.
You're welcome. Woo!
Woo! Kenneth, are you there? We got you on. Jerry, did you want to unmute?
No,
Kenneth?
I'm hoping everybody will click on mute and tell Kenneth hello, and thank you so much for being here tonight.
Yeah, Ken, you're muted.
There we go.
There
Hey,
you go,
everyone.
Ken.
Thank you so much for the warm welcome. We are sorely needed with today's temperatures. You guys are very kind. I love how it says in there, Bank of America's worst nightmare. That's my ultimate dream, is to be their worst nightmare. And I don't think they're done with me yet. With you guys' support and help, I think I think they have a comeuppance coming along with all the other big banks. You know, they really all operate the same way in my experience. It's just Bank of America has that little bit of extra evil, that little bit of extra chutzpah to say that they are, you know, to hide behind the American flag and the American colors. And I think that makes them just a tiny little bit even more disgusting than their colleagues. So I guess what I thought I would do today is just sort of maybe talk for about an hour. And then I know since we have 2 hours allocated for this presentation and conversation, maybe I could allocate the second hour to some questions and answers. I may not have the answers, but I might be able to help you find them for the ones that I'm not too sure of. And you know, obviously, I'm not supposed to be giving legal advice. That's one of the many absurd restrictions that are placed upon me. It's sort of like, technically, by the way, I'm suspended from the bar, not disbarred, but I only point that out because I like to maintain truthfulness. And technically, I was suspended, and then they denied my reinstatement on, you know, various bogus grounds. And, you know, I understand that most of you have watched or listened to the interview that I did with Matthew Cox, Inside True Crime. So I'm going to try to not rehash a lot of the materials that were in that video. I'll try to not be one of those people that's a member of the Department of Redundancy Department, as they taught us in law school, to try to avoid. So hopefully that won't be the case. I'd like to just start out, if I can figure out how to share my screen, going through some of my activities during my years of being the foreclosure destroyer, so to speak, showing you some of the things that I experienced that were not able to be seen on Mr. Cox's video. For one thing, I wanted to start out showing you guys the assignment of mortgage that really opened my eyes, the one that I spoke about on Matthew Cox's video, on whatever we're going to call that. I need to come up with a name for that, I guess. But the first thing I wanted to basically show you guys was that assignment of mortgage. So if I can figure out how to operate this highfalutin technology here, we'll bring that up. So I made a folder just for this presentation. Of course, it doesn't appear to be here. Isn't that wonderful? Webinar, there we go, 2026. All right, so here is the infamous assignment of mortgage, the document that I got in my very first foreclosure case. Are you guys able to see that?
We are not yet, Kenneth.
Well, I did click share screen, so let's see if we can figure out why we're not doing well here technologically. So I'm going to go back to, all right. So I click share screen and it says multiple participants can share simultaneously. Clicked on that. And I guess that is not sharing my screen. Oh, I can see how I'm. See here.
You need to select the window that's open on your screen. You should see a panel.
The window that's open on my screen. I mean,
Yeah, when you click share, a window
okay. Try
come
this.
up. And
Yeah,
then
there we go. Can you guys? Oh, I have to click share. There we go. How about now? I am screen sharing. Okay.
There we
All right.
go.
There we go.
That works.
Progress in the age of confusion. I like that also about the intro, that they rely upon confusion to continue with their criminality. I think that's a great description. I haven't heard that before. So you guys are able to see this, correct? Or no?
We are.
Okay, awesome. If it's not at 1%, you'll be able to see it.
That's it.
1%, that's kind of our enemies in this battle, in my opinion, you know, the 99% versus the 1%. I learned that language going to a couple of Occupy Wall Street rallies. So this little doohickey right here is something else. And this is what really blew my mind, okay? You can see my notes there. But for one thing, we have the two different people with identical signatures. You guys able to see that? And then I guess you're not able to answer because you're all muted. That's fine. And then we have the other signature over here. So this is what I was describing that night after the mediation when I went back to my office and I found this, and I just couldn't believe my eyes. It took me a few years to realize that this signature here for the second witness is actually the same.
You know, like,
Pardon? It's actually the same signature again, just like 3 times and scrunched together. And, you know, the notary obviously can't be the same as the person from the bank who's transferring this loan with her signature. So that was the one. I mean, to me, that double S thing, I don't know, it reminds me of the Nazis or something. It's just so sinister, you know. And this is an example of what I would call the ancient Greek sin of hubris, where, you know, these people were signing so many of these documents every day. They didn't give a shit what it said. They didn't care one way or the other. They didn't even know the significance of it. And they were just so overconfident in their having gotten away with it for so long that, you know, they weren't paying attention. And she accidentally signed the same fake signature on all the lines. And I was able to take this lady's deposition at one point, Cheryl Salmons. That name will live on in infamy in my mind as well. So that is the infamous assignment of mortgage that began my journey through foreclosure fraud and MERS and all of that. This was something, when I really understood, this was the first thing I did. I can't draw, but I mean, this little stick figure is probably the best stick figure I ever drew in my life. And what this is intended to represent is sort of like me saying, I see you. Then we have MERS. They're saying, run, he knows everything. Citi and Stern and Fargo and Freddie and Fannie. This is me saying, burn liars. This is the website that I created. And then this jet up here in the upper right-hand corner is my conception of the 1%, the Illuminati, if you will, the people behind the scenes that orchestrate all of this exploitation of the hardworking, salt of the earth Americans like ourselves. And this is them, jetting off for Aruba or whatever, someplace where there's no extradition treaty. And, so far it hasn't really turned out like that, but I still have high hopes that it will. Even if it doesn't happen in my lifetime, one day there's going to be some change. And you guys are all part of this, part of that process. I'm part of that process. And, we all suffer and we pay the price. But even if we don't reap the rewards for our honesty, integrity, advocacy, and truth during this lifetime, it's still, we're going to reap that benefit for our descendants, our children, our grandchildren, that kind of thing. And that's the exact same kind of sacrifice that was made by, our founding fathers. They risked their own lives and, those of their friends and family to set up a situation where their descendants would have more freedom and better government than they had in their lifetimes. So, don't ever get discouraged or, bow your heads in disgrace, because you guys, and time will tell, history will show that you guys are on the right side. We're on the right side. So, I filed that class action lawsuit, and there were some articles that came out. I mean, to be honest, I thought at the time I was well on my way to being, a hero to the people. Little did I know I was going to be, run out of town and disgraced, basically. But thanks to my belief in God, I've been able to handle it, and hopefully, you guys' assistance, I'll be able to have a more powerful megaphone, and what I know will be able to be spread to a greater degree and extent than it would if I still had my license. So this one, foreclosure crisis, as you can see, California was first, Florida followed, with the second highest number of foreclosures in the nation during the first 6 months of 2010. Attorney Kenneth Eric Trent of Oakland Park won a foreclosure case by challenging the mortgage industry as a fraud. He is now preparing a class action lawsuit against Mortgage Electronic Registration Systems, Inc., or MERS, which is the clearinghouse of sorts. Look, they can't describe it. One of the things I didn't mention in my interview with Matt Cox was there's a decision of I believe it's the Kansas Supreme Court, where they said listening to these lawyers trying to describe MERS and what MERS does is similar to the ancient fable of blind men, each of which is touching a different part of an elephant, trying to define an elephant, because that's what it is. Nobody can really pin it down or explain what it is, but I think I can. And as it says here, according to Trent, MERS allows banks to claim they are the owners of the note when they are not. Trent successfully challenged MERS authority and validity in a recent case. He is now preparing a class action lawsuit over the issue, which he expects to be duplicated around the country. He has set up foreclosuredestroyer.com, although they misspelled it, where consumers can join the lawsuit. Well, life's never perfect, So after that, I guess what else? So then after I filed the lawsuit, this article came out. Homeowner files fraud suit against firm lawyer. David Stern, this is the guy that had the boat that was entitled Su Casa es Mi Casa. The suit claims that Stern and his plantation firm violated the Racketeer Influenced and Corrupt Organizations Act as they pressed foreclosures against distressed homeowners. The suit, filed Monday in U.S. District Court, alleges that Stern employees and attorneys filed fraudulent court pleadings, filed suits on behalf of lenders that didn't own debt on the homes targeted for foreclosure, and concealed plaintiffs' lack of standing to foreclose on properties. Stern did not return a call seeking comment. I mean, I won't read this whole thing to you guys, but anybody who wants to see it, let me know and I'll be happy to send it to you. It's a pretty, at its heart, I just want to read this part. At its heart, the suit challenges the legal methods used by many law firms that have churned out hundreds of thousands of foreclosure cases on behalf of bank clients since the economic crisis started 3 years ago. And Stern's attorney, of course, denied any wrongdoing. Then I also wanted to show you, somewhere along the line, I have to confess that I went to something called the Ultra Music Festival in Miami, which is basically an electronic music festival. And I went there. This is what I had stuff. I used to use those, just married sort of markers to write stuff in my car windows. And I was kind of proud of this one. So, I would try to influence the younger generation whenever I could. So this is just one example of things I used to write in my car windows. Banks are ultra liars, because it was the Ultra Music Festival. And then let's see. What else do I want to show you? Well, I made some t-shirts and some bumper stickers featuring Skank of America and several others. Here's sort of not a menage, a collage of some of my designs, which I was pretty proud of. Of course, the banks change their names every 5 or 10 years, so I need to update this. It needs to say, since SunTrust changed its name to Truist, I need to come out with a new one that says Falsist. Wells Fargo, of course. And I would go around with my megaphone from time to time by the beach and sort of state some of these things to people in the area. And to get something a little bit more tangible that you guys may be able to use in your own foreclosure battles, this is something called Memorandum of Review by the Office of the Inspector General, U.S. Department of Housing and Urban Development. And there's one of these for all of the, I guess you would say, the big 5 banks: Skank of America, Wells Fargo, Citibank, Untrust, and Chase. And so there, you guys can use these in foreclosure matters because they're really powerful official government impeachment of the evidence used by banks in foreclosures, and just their practices in general. So as it says here, you guys can find these online for whatever bank you're dealing with, or in your case, you'll be able to find one of these that comes to similar conclusions. This just happens to be the one for Wells Fargo. As part of the Office of Inspector General's OIG nationwide effort to review the foreclosure practices of the 5 largest Federal Housing Administration mortgage servicers, Bank of America, Wells Fargo, Shitty Mortgage, JP Morgan Chase, and Not Your Ally Financial, used to be GMAC Mortgage, we reviewed Wells Fargo's foreclosure and claims processes. In addition to this memorandum, OIG issued separate memorandums for each of the other 4 reviews. We performed these reviews due to reported allegations made in the fall of 2010, largely from me, that national mortgage servicers were engaged in a widespread questionable foreclosure practices involving the use of foreclosure mills and a practice known as robo-signing of sworn documents in thousands of foreclosures throughout the United States. And if you look at the footnote 2, we have defined the term robo-signing as the practice of an employee or agent of the servicer signing documents automatically without a due diligence review or verification of the facts. I won't read this whole thing to you guys, but it goes into the national mortgage settlement, which turned out to be a joke, unsurprisingly, when you're dealing with these people. So we keep on going down here, and you'll see how Wells Fargo conducted itself in response to this investigation. Our review was significantly hindered by Wells Fargo's reluctance to allow us to interview employees or provide data and information in a timely manner. Wells Fargo provided a list of 14 affidavit signers and notaries, and then initially restricted our access to interview them. Wells Fargo attorneys interviewed them first, and then only allowed us to interview 5 of the 14 affidavit signers. That's the ones who would lie, presumably. Wells Fargo told us that we could not interview the others. This is a moment of uncharacteristic honesty, because they had reported questionable affidavit signing or notarizing practices when it interviewed them. After discussion with attorneys for Wells Fargo and OIG counsel, terms were agreed to, permitting us to interview these remaining 9 persons. The terms that Wells Fargo set required that Wells Fargo management and attorneys attend all of the interviews as quote unquote facilitators. That's kind of like servicer. They make up these new terms and labels for their minions. This condition resulted in delays and may have limited the effectiveness of those interviews. You think? Wells Fargo's terms also required that persons we interviewed have private counsel present on their behalf. However, as work progressed and through other research, we began identifying many more affidavit signers and notaries that Wells Fargo did not disclose to us initially. Wells Fargo ultimately disclosed 35 persons, and we interviewed 33 of them, 22 affidavit signers, and 11 notaries. We did not interview 2 other persons because they were paid to not be around. Wells Fargo, the government's quite polite here, did not establish effective control over its foreclosure process. This failure permitted, guys, it didn't permit a control environment in which it orchestrated a control environment in which. This is one of the things I've observed about these people, you know, the 1%. They disguise pure, diabolical, criminal, organizational activities as, you know, mere incompetence. It's not incompetence, guys. They're not incompetent. Believe me. They run circles around the regulators. They certainly run circles around, you know, judges that you guys deal with and that I dealt with for so long. Just for example, here are some of their, you know, dramatically understated conclusions. The affiants routinely signed and certified that they had personal knowledge of the contents of documents, including affidavits, without the benefit of supporting documentation and without reviewing the source documents referred to in the affidavits, and with a run-on sentence verifying the accuracy of the foreclosure information stated in the affidavits. A number of affidavit signers admitted having signed up to 600 documents per day. Guys, this is barely scratching the surface. There are actually affidavits of former Skank of America, Wells Fargo, and Chase employees that explain, you know, in greater detail that they were actually incentivized. The more loan modification applications they could deny in a single day, just like in this case, the more affidavits and assignments of mortgage they could execute in a single day, the more they would receive in terms of payment or other forms of compensation like gift certificates and that kind of thing. So what they actually do is they incentivize this evil that destroys people's lives, destroys the American dream, causes so much destruction in terms of decent, hardworking, salt of the earth human beings, the 99%, great Americans, great, you know, humble, hardworking Americans, law-abiding citizens. They rip our hearts out. I mean, the amount of divorces, you know, substance abuse relapses, suicides. I mean, it's an untold story that I hope history will tell one day. It was caused by the practices of these diabolical, you know, overlords, the oligarchs. These people actually, you know, they would lead you to believe that you're getting a loan modification. That's their one of their favorite tactics, so that you wouldn't actually respond to the foreclosure lawsuit when you got served with it, because their milquetoast would be on the phone telling you, leading you to believe, without directly stating it, that you are going to get a loan modification, a payment that you can actually manage. It might be difficult, but you know, because you're a hardworking person and you're industrious, you're going to do it. You're going to be able to pay those payments. And, you know, but you'll have to pay those 3 trial period plan payments first. And if you are going to be doing that, it's kind of hard to go out and retain a guy like me, one of the few attorneys who actually fight for their clients in foreclosure court. If you can find one in your state, pretty hard to pay our retainer fees when you have those 3 trial period payments going on. You know what I'm saying? They put you in a bind where you have no choice but to believe them, trust in them. And what ends up happening inevitably, and this was incentivized, this was directed behavior by all the big banks. They were supposed to be giving people a high number of modifications they got taxpayer dollars to do that, guys. And, you know, in exchange, what did they actually do? They denied those loan modifications and put everybody in a terrible, heartbreaking position where they have failed to respond to the foreclosure complaint. Time has run, and they are, from that point on, they're pretty much SOL. They thought and the bank has taken their last bit of money for these 3 trial period payments, and then has told them, oh, too bad, so sad. The investor did not approve your loan modification application. And at that point, it's too late to get an attorney and respond. They don't get their payments back. And now they don't even have the money to try to move somewhere else to be able to, you know, at least land on their feet somewhere. And that's just one example of uncountable numbers of evil practices that all the big banks share in common. Now, I'd like to talk a little bit more about some of the questions that you guys sent me. I'm hoping that now my face is visible on the screen. Somebody could give me a thumbs
Sure is.
Someone's right shoulder.
You are good.
Yeah, it's a cool. I appreciate that. So I've seen these questions that you guys gave me, and I'm going to try to go through these one by one. Hopefully they're in something of chronological order. You asked me about securitization, sale, and traceability of the instrument. First question: when a loan is transferred from the originator or servicer to a securitizer and later resold or enforced by a trustee or third party, what documented transaction actually takes place that is legal? I mean, my answer to that is, from our perspective, from our vantage point, the approach to that is to find the pooling and servicing agreement. It's usually available online. Sometimes they get a different title. It might be just called servicing agreement. But those pooling and servicing agreements, they actually set forth the roles of these various financial institutions in this securitized trust. So, for example, it'll say, Wells Fargo is the servicer, Douche Bank is the trustee. That's a joke, by the way. You're supposed to say Deutsche, but I call them Douche Bank. I have my little nicknames for all of them, as if you haven't gathered that by now. But say Deutsche Bank is the trustee and somebody's the master servicer, and Double Wide Home Loans is the, whatever. And then there's a series of endorsements that are supposed to be placed on that promissory note before it actually is physically delivered, the blue ink promissory note, to the trustee. And sometimes the trustee also has a custodian, which could be like Recon Trust, which is one that Skank of America allegedly used. It's just another level, another layer in the entities that gives those banks, plausible deniability. You can always point your fingers at somebody else. And the thing that all these practices have in common, guys, is they prevent you from finding out who is the man behind the curtain. When I want a loan, I'm trying to get a loan modification. They're jerking me around. I've got a different, quote unquote, single point of contact every time I speak with these people. I'd like to talk to the head honcho, the HMFIC, the Queen Shiznit, whatever you want to call them. You can't find them. You can't get to them. And if you really bother them, the next thing you're going to get is another assignment of mortgage. Well, as some of you guys might know, there is a process. These trusts, I mean, the name just blows me away. Trust, I mean, that's the exact opposite of what they should be named. But, it's kind of like, I mean, a trust, how dare they even have the nerve to use that word? I mean, in my belief system, when it's their judgment day, that's probably going to be a pretty highly featured item on the list of their conduct that's being held against them. I mean, trust, the nerve, the stones to call themselves a trust. That's a sad, tragic, ironic misnomer for sure. They're all tax exempt, guys. So while we're paying taxes, well, I don't want to be a hypocrite. Well, you guys are paying taxes. What's going on is they are tax exempt. So each one of these trusts, which has a name, it sounds like a trigonometry, that I didn't understand in 10th grade. Literally, they are tax exempt. But as a condition of their tax exemption, and this is provided for in every single pooling and servicing agreement, they have a closing date. And the significance of that closing date is that no loans can be transferred in or out of that trust after the closing date. If that happens, the consequence under the federal codes, the IRS code, is that entity forfeits its tax exemption and pays a tax penalty to the U.S. government of 99% of that trust's face value. I've looked at hundreds of these trusts, and I've never seen one that had a face value of less than $100 million. Okay. So 99% of that is $99 million. And that's the smallest trust that I remember encountering. So that money is supposed to go back to the federal government. So every time they do one of these bogus transfers in your foreclosure case, you get a fake ass robo-signed assignment of mortgage or endorsement. What that's doing ostensibly is transferring your loan in or out of that trust after the closing date. And there's a process by which whistleblowers are supposed to be able to turn criminals in to the federal government who are not paying their taxes. And if they do that and the government recovers the unpaid taxes, then the person who turns them in, the whistleblower, you or I, is supposed to get 10 to 20% of that total revenue as a reward for turning them in. Like many other aspects, if not all aspects of our federal government, when it comes to banks and mortgages and foreclosures, they are completely dysfunctional because I had a coalition of people. We had like 6 complaints. We had an accountant, a former IRS agent, myself with a law license, the client whose case that the fake document had been filed in. Oh, it should be if the government were functional and not totally corrupted by the 1%. I mean, we had our I's dotted and our T's crossed. So we would just take that fake assignment of mortgage filed in the foreclosure case. We would present that along with like the pooling and servicing agreement. We were sending them, I don't know, whatever the really big binder is, like 12 inches. We were sending the huge binders of, all the information they would ever need to see that, we would send them the pooling and servicing agreement for this trust that the loan was allegedly placed into. And then we would send them the document from foreclosure court, which was presented as sworn evidence to show, voila, that loan is not in this trust. They're over here transferring it to somebody that has nothing to do with this trust, just to foreclose on you. And we would just get back form letters of rejection, half a page. Does not meet our criteria or something. No explanation. They turned a blind eye to it. I believe that's the same reason that my amazing, awesome class action lawsuit against Stern and MERS, Bank of America and Citi and all the founders of MERS, which you can look it up online, the shareholders in MERS, there's like 25 of them there. It's just it's basically the name of Satan's, a roster of Satan's, angels, as far as I'm concerned. They absolutely, what was I saying? Yeah, they were able to escape from that class action because I believe of the theory that banks are too big to fail. That's probably the same reason that whatever bureaucrat in the IRS, whoever it was, made the decision to reject our amazing whistleblower petitions or, reports as, not sufficient. I mean, there's nothing could have been more sufficient and more apparent than the truth of my lawsuit and also the truth of those reports that we filed with the IRS. That doesn't mean you shouldn't try. I found that, any way that you can put pressure on the banks, you can start any kind of collateral proceeding whatsoever that's related to your foreclosure, they will stop. They will stop prosecuting the case. They will freeze in their tracks. And then you'll have another year or something of battling them, or 2 years or 5 years before they ever get back around to actually trying to proceed with the foreclosure again. You asked, being heard in court, why the system ignores homeowners? That's a good segue there. I mean, I don't know. I will tell you that in Florida, one of the other completely awesome, aggressive foreclosure defense attorneys in Florida was a guy by the name of Mark Stopa. Extremely smart, extremely aggressive, maybe a little too much if you'll excuse the slightly prejudiced, stereotype, a little too much Italian blood, because, he would kind of lose his cool, I guess you would say, with some of the judges and tell them to their face that they were corrupt and start cursing at them and stuff. And that's probably not a really good idea if you want to keep your law license, especially when you're a kick-ass lawyer that's, wreaking havoc on this evil paradigm and the robo-signing crap that was going on. So, Mark Stopa, he actually has written a book. Mark's theory was that I knew this as well, but he took it one step further. The judges tend to have bank shares, bank stocks in their retirement portfolios. So when you're a 60, 70-year-old man, whatever, 50-year-old man, and you're a judge, you're not making a ton of money. You're not getting rich. You're able to live a nice lifestyle, but you're not, you don't have millions in the bank unless you do something dishonest. But the thing they're counting on is having a really cushy retirement where they don't have to work a 9 to 5 and they have, so like in Florida, Mark Stopa, exactly. So in Florida, he has a book I'll think of the name. Maybe you can look it up. Something about money. He's got a dollar sign on the front. I know that. But Mark, who truly was an awesome attorney, probably won more foreclosure appeals than the rest of the good foreclosure defenders in Florida combined, just because probably he had the Second District Court of Appeal, which was more open to homeowners appeals. But nonetheless, the man did great work. His book, his theory is that, well, he actually did a study, but the obvious thing is, because the state of Florida, it bought these same securities that we're talking about and put them in the retirement funds for, say, for example, state of Florida government employees who have retired. So that's the way that their retirement accounts are going to be funded, is the performance of these same trusts, the shares in these same trusts that we're talking about. So they have an incentive every day. If they were to say, well, this is a fucking fraud and I'm throwing you out, this case and all the other Wells Fargo cases are thrown out. Well, what's going to happen? Big news story. Wells Fargo stock tanks. Next thing you know, the value of their retirement portfolio tanks right along with them. And Mark did yeoman's work. He, as I understand it, I haven't read the whole book, but I know what it's about. He actually did some public records requests. That's another great tool in the fight, to find out which judges had, which retirement accounts and what were the shares that they, or the companies that they held shares in. And then he actually did a study to trace their level of fairness to homeowner defendants in foreclosure court. And I believe he was able to establish that there was a statistical correlation between how much their future was involved, tied in with these bank stocks, and versus how adverse they were to homeowners in, continuing to grant final judgments of foreclosure, despite the overwhelming evidence that, the whole thing is a huge fraud and the bank has no standing. Another thing is, judges don't read. They don't read the paperwork. Most of them, they just don't give a shit. Sad to say, sad but true, that's how it is. The banks take advantage of that. I know during the foreclosure boom, or whatever you want to call it, the foreclosure debacle, back when, I was being judges' chambers trying to argue motions in my first foreclosure case, and the judge, who has like one law clerk and one secretary, she's got files, so many files on the table and on the floor in her chambers, I can't even see Her Honor's quite attractive face from 3 feet away, So it's like she's so overwhelmed. There's no chance that she's even reading this stuff, no matter how well-intentioned she might be. We all know that these people are not, invariably just evil bastards. It might seem like that when you're dealing with their rulings, but they always act like, I'm sorry, I don't know how to look exactly at I don't want to necessarily look at the chat for Telegram. The last thing I have here is from the illustrious Tammy Bradbury telling me I'm on. Yes, please. Thank you, Tamara. Do you say it Tamara or Tamara? Well, you can tell me later. Anyway, she's great, and I appreciate her giving me this opportunity and bringing me on today. So, you wanted to know, what do judges actually respond to versus what they routinely disregard? They actually respond to bullshit from the plaintiff's attorney. I'll say that much. They can't even justify their rulings, guys. In my experience, you'll sit there in court and kick their asses all day. I could give you transcripts right now at my fingertips. Of course, they're 200 or 300 pages where I absolutely destroyed every witness they put up there, ripped them a new one in casual parlance. And the next thing you know, the judges, they'll sustain every objection. They'll take our side in every exchange, but yet when the decision comes out, usually not in your presence, go home and wait for it. It's just a one-liner, judgment, or just a form final judgment of foreclosure. No explanation, because they cannot articulate any legitimate basis whatsoever to rule in favor of the bank, and yet it seems like they almost invariably do. So I know that one of you wanted to know, what's a way to win these cases instead of just actually delaying them? I don't know what that phone symbol means in the middle of my screen, but hopefully you guys are still hearing me. I don't know, guys, is the truthful answer. I mean, you're not going to get platitudes from me. Probably if I were more subtle and less direct, I would still have a law license. But just for the record, by the way, I was a gentleman in court. I didn't go in there, cursing out the judges. I mean, I definitely thought the things that Mark said, but I didn't get tossed for just being a raging a-hole. In fact, most of my opponents liked me and had a lot of respect for me and tried to help me get reinstated. So, I mean, the most effective things that I've seen were where you set depositions that they cannot allow to occur, and you get the banks to voluntarily dismiss the case. I've had that happen several times. Or you force them to respond. You get an order from the judge compelling them to respond to a discovery request that they cannot possibly respond to. I mean, examples of that are, whenever you get an assignment of mortgage, the first thing you need to do is send out a notice of taking, deposition, duces tecum. That means, and bring, where they have to bring documents, DUCES, TECUM. Nobody knows how that's actually said because it's Latin, and Latin is dead as a spoken language, but most common pronunciation in the legal profession is duces tecum. They are never going to allow the person who signed your assignment of mortgage or your endorsement, in most cases. I know there have been a few depots taken, but by and large, they will ultimately dismiss their case if you can keep forcing them, don't let up, keep getting court orders to produce this certain person to take a deposition, because they are never going to do it, because they still have this massive evil fraud that we're here about today, that I'm talking about, to worry about being exposed. So they still have that vulnerability. So I would say overall, the best way to win your foreclosure case is to pressure them hard in discovery and in depositions to present people for deposition that they cannot ever allow to be deposed, or to force them to produce documents and things, or to answer questions that they can never actually answer. You're going to get you get these screenshots that show that foreclosure counsel received the original promissory note from whoever they have as the plaintiff in your case, which is invariably a lie. Doesn't relate to any real world ownership of your mortgage. They have a fake ass document. They call it a screenshot usually, that's going to show that they received the original documents, and then they'll have some kind of cover page that goes with it, because theoretically you can't transmit the original documents by computer. So they have like a cover letter that ostensibly comes to them via FedEx, and they'll give you a fake ass FedEx printout. But if you look up the tracking number, nothing ever comes up. And if you tell them that you want to take the deposition of the person who signed that cover page or whatever, they'll never ever going to produce that person. They might not even exist. But they won't give you that screenshot until just before trial, if ever. So that's another thing. You have to insist really early in the case on discovery of all exhibits you intend to present at trial. And when they give it to you, or they give it to you with that bullshit equivocating language about, it's not yet been determined, whatever, you have to continue driving and dragging them to court on motions to compel them to produce that document, that evidence, and to allow you to take the deposition of whoever, wherever they use one of those fake ass names that usually sounds like a man but could be a woman, or vice versa. Whenever they use one of those names, that's the person you go after. You set their deposition. You do not allow yourself to be denied. You take it in front of the court, no matter how much the judge may roll her eyes or sigh loudly when they see your face. Don't be denied. Don't stop. Keep pressing on that point, and eventually you'll get a voluntary dismissal. That's my experience. As far as getting the judge to throw out the case, I mean, it happens, but it's few and far between. And usually it is on one of those things sort of like related to discovery, like, Judge, we have 5 orders here to produce this person for deposition, and they have refused to show up. Eventually, you might be able to get a judge to dismiss the case without prejudice. And in Florida, there's no such thing as with prejudice practically, because the judges made up this theory that they can sue you even if you haven't paid your loan since 2015 or 2005. They can sue you again and again and again and again to foreclose, because every month when you don't make the payment, supposedly that starts the clock on the statute of limitations over again. So at that point,
they're not past the statute of limitations and they can sue you again. And it's a new default. So even though you won the prior foreclosure case, this is a new cause of action because it's based upon your new missed payment. You know, that's the sophistry that somehow the bankers' lawyers have talked Florida judges into adopting. I don't know whether and to what extent that's the law in other states, but probably is. I've found in my experience that even, you know, though Florida is a judicial foreclosure state, and many of the states I'm sure you guys are in are non-judicial foreclosure states, it's still the same racket, and for the most part, the same rules apply. It's just that in the non-judicial foreclosure states, there's more of a burden upon the homeowner to file a lawsuit and come in and bring evidence. But with the tools that I'm giving you today, hopefully those of you who are in that position will be able to do that and more effectively. Just for example, those reports of the Office of Inspector General as to the foreclosure practices of the evil ones, the 1%. Robo-signing, proof, admissions, and strategy. If assignments of mortgage or deed of trust are clearly robo-signed, how does the petitioner prove that in court? Notice of taking deposition of Linda Green. Notice of taking deposition of Jack Spratt, of Dewey, Cheatham, and Howe. And notice of deposition, send a letter, send emails to the opposing counsel saying, I've got the following dates. I'd like to take the deposition ducus tecum of, whoever. And that's the way to go about that. And you can also look online. There are some websites which have, basically, if I have a fake ass signature in my case, which almost invariably I do, I am just going to go and look up their name online. And I'm going to find some other assignments of mortgage filed in some other official records in some other state or in my state. And I'm going to compare their signatures. And I'm going to compare the roles that these people allegedly have in those documents with the role that they allegedly have in the bank for whom they allegedly work. In my case, and usually it's somebody different. So if I find a document that says Linda Green is assistant vice president of Douche Bank, in Georgia in 2017, and then in my case in 2019, Linda Green is a vice president of, I don't know, WAMU, or I guess WAMU was out of business by then, but whoever the hell they're calling, whatever they're calling themselves these days, then I've got something. Or their signatures won't look anything like they do. The signatures look on the other official records. So you're able to bring that into court. And if you can get the judge to actually read something, maybe you should put it on the front page, because if you get them to read, that's about how far it'll probably go. All right. For homeowners not yet in foreclosure who discover robo-signed documents in their chain of title, what proactive process do you recommend before enforcement begins? Good question. In Florida, we have a beautiful statute. It's called, well, I don't know what it's called, but the statute number is 817.535. And before I came on today, I did a little handy dandy AI search, and I asked it the question, do other states have laws similar to Florida statute 817.535? And AI says, si, senor, they do. And it says several, it says many states. It looks like it's about 17 states have similar laws. Now, here's what 817.535 does in Florida. It gives you a private cause of action for anybody who records an instrument in the official records of your county that affects your property that contains any false, fictitious, or fraudulent statement or representation. So, for example, I've got a fake-ass assignment of mortgage. They recorded it in the official records. I can file a lawsuit. Kenneth Trent versus Skank of America under 817.535. And I can allege I am the owner of this property by virtue of this warranty deed, recorded at book and page number, having instrument number. And then on such and such date, Skank of America recorded this here, fake ass assignment of mortgage with a fake ass non-authoritative individual signature on there who doesn't appear to have ever walked the face of the earth. And so therefore it contains false, fictitious, or fraudulent statement or representation. In Florida, that statute, not only does it authorize, but it requires you as the plaintiff to file a notice of lis pendens against your own property. Now, that might sound like a problem, but it's more of a problem for the other guys than it is for you. Because now they can't, usually in Florida, the bank or one of their minions, one of their pseudonyms, is the winning bidder at your foreclosure sale. And what they're doing here is they're flipping your property so they can give somebody else an exploitative mortgage. So they normally are going to be the ones that they're planning to be the winning bidder at your foreclosure sale and then flip your property so that they can scam somebody else into a death trap mortgage. And they can't do that if you have a lis pendens recorded against the title to the property. So even if you've already had the foreclosure sale, you can still file your notice of lis pendens and your 817.535 or equivalent action, and you can tie up the property. So the bank assholes cannot flip your property because now it's tied up and nobody is going to buy it because that's the official, because you're asking for some kind of relief regarding the title to your property. So that property, even if it's not technically yours anymore, if you're still fighting for it. So at that point, you have leverage, you have power, and you are the el jefe or the boss in Spanish to them for once you have the upper hand. That lis pendens is a very powerful instrument. Beat them at their own game, so to speak. And then, so you can get equitable relief, which means an order from the court that invalidates this particular instrument. Now, it's not going to invalidate your mortgage unless theoretically you can prove that the mortgage contains false, fictitious, or fraudulent statements or representations. I know that someone in this group, I'm not quite sure who, because I just found out about you guys in the last couple of days, but maybe it's Mark. But I know that there are many other potentially viable theories and arguments as to why the mortgage itself contains false, fictitious, or fraudulent statements and representations. That's not necessarily my bailiwick, but if you can identify that, you can file an 817 or equivalent action based on that mortgage, because the mortgage is also an instrument, just like a lis pendens, just like an assignment of mortgage. Anything that's recorded in the official records, if there's anything false, fictitious, or fraudulent about it, you can file one of those lawsuits and you can attack it. And the statute specifically authorizes the court to invalidate the instrument, remove it from the official records, seal it, and tickle me pink, you can get an order prohibiting that financial institution from filing anything in the official records for any period like 5 or 10 years or maybe forever without prior court authorization. Now, I haven't pulled that off. I'm not saying I have, but that's what it says clearly in the statute. And it certainly nobody can say that your argument is frivolous. And meanwhile, you're tying their ass in knots, and they're going to probably want to come to the table and negotiate something so you can keep your house, because all you need is to win one of those cases. One of them goes through, then that's a huge problem for them. That's a huge precedent. Plus, there's the potential devastating impact they have to face of not being able to record any fucking instruments in the official records. And that would completely destroy their entire business model, and it could change things forever. So that, I think, really is the best leverage you could possibly deploy against these criminals. Yeah, under 817.535, you can also get damages, but you can also get attorney fees. So, you can pitch this to people who have a license and, maybe get them to take it on. And when you have attorney fees and everything your attorney does is potentially having to be paid by the other side, that can cause them to change their position quite quickly. Does a corporate assignment executed through MERS carry any real weight in a foreclosure case, especially where the note is not produced? In Florida, they've come up with all sorts of bogus legal theories to try to get the workaround on the fact that all of their documents are fake, especially the assignments of mortgage. In Florida, they've convinced the courts that assignments of mortgage do not affect standing. Only endorsements do, because the homeowners advocates and homeowners haven't quite come up with the overwhelming evidence that all the endorsements are fraudulent that we have come up with as to the assignments of mortgage. They're no less fraudulent. They're no less robo-signed, but the evidence just hasn't been as fulsome. So I think the answer to the question is, at least in Florida, the judges do not give a rat's ass about your robo-signed assignment of mortgage. I'm sorry to tell you. Now they should, because it's a felony to file fake documents in court. Last I checked, if I did that or you did that, we would be in some seriously hot water. But they turn a blind eye largely. So in my experience, judges, if to the extent they're listening to you at all, probably going to listen more as to the endorsements, or even better, like fraud upon the court. Okay, when they file these fraudulent documents, you show them the robo-signed signatures, you're able to break it down in some way that they're going to listen, that the assignments of mortgage don't match up with the requirements of the pooling and servicing agreement, and therefore it's impossible for this loan. Like whenever they say, oh, there was a lost note, inevitably, if you do enough discovery in a case, you're going to find that somewhere in the past there was some kind of an affidavit filed saying that they cannot find the original promissory note to save their lives. Now, I have my theories on why they do that or did that, but it's not really, in my opinion, because they can't find the promissory note. Guys, if you're in this business long enough, you'll learn that whatever they say, 99% of the time, the opposite is true, because they don't give you information without being really forced to do it or having an underhanded agenda underlying that ostensibly open disclosure. So when they say, anything they tell you, you have to figure is probably either the opposite of what is actually the case, or is intended for a purpose that you can't quite perceive. It's setting you up for some kind of an unfortunate ending in the future. And that's why they do these lost note affidavits and all that shit. But inevitably, there's going to be one somewhere in your file, if you could get the quote unquote servicer's quote unquote file, or, sometimes they accidentally send those over when they don't have anything that's actually responsive to your document request. I've seen that happen in Missouri where, the guy's fighting a case for 10 years and they never said the note was lost. And then when he does some kind of discovery request or I can't think of the term right now because I haven't been practicing recently, but those letters where you send them out and they're required to give you all the evidence and stuff like that. Somebody will think of it in this group, but you send them one of those letters, all of a sudden you'll get this thing. It's like a gift from God, lost note affidavit. Well, ladies and gentlemen, boys and girls, if you take a look at that pooling and servicing agreement, if there's a lost note, there were all these procedures that had to be followed to replace it. But the trust doesn't have lost notes, guys. Your loan would have never been in the trust if the note was lost. So that's another way that you can stick it to them and show court in a way that they're actually going to understand. Usually at trial, because that's the one time you might get an audience where they're halfway, where not only are the lights on, but someone at least part of the time is home. I mean, I don't assign the judge's unfairness to, oh, they're all just evil people. I think it's more lassitude, being disenchanted, bored with their job, having too many damn cases, feeling overworked and underpaid. They just tend to get lackadaisical, I guess you would say, or so egotistical that they think that nothing that you could possibly put in those papers would affect their predetermination of your case. I've seen that a lot, to say the least, where there's a hilarious transcript in my book. It's a case down in Miami, a very, very effective foreclosure defense attorney, Joshua Bleil, B-L-E-I-L. He's come in for foreclosure trial, and the judge, this horrible human being named Michael Gendon, G-E-N-D-E-N. The judge, just an extremely abusive man. I call him the artist formerly known as intelligent, because once upon a time, theoretically, this guy was damn smart. He's no slouch when it comes to brains. But he's, over the years, his ego has expanded to the point that he's not listening to anything. He's already made up his mind that everything the defense is saying is bullshit. These foreclosures are all a waste of time. He's got 50 people in his courtroom for one afternoon, 50 cases, and he's just there to rubber stamp them and get out so he can have a beer, and trust me, he's an asshole. And he's sitting there, and I've been in front of him, but I could tell you a story about me and him, but anyway, this transcript in my book is just, to me, absolutely puts me in stitches. I mean, it's a tragedy, but it really illustrates the point of how judges treat homeowners. So I got 50 cases. The whole room's full of lawyers, and all of them are going up there. They're being seduced into agreeing. Oh, we'll agree to a judgment. We're going to give you an extended sale date. You can process your modification, then you'll be fine. Rubber stamp, rubber stamp, rubber stamp. These people have all lost their homes. Well, here comes Joshua Blyle. Joshua Blyle is ready for an actual trial. He's got a court reporter. He's got a big ass box. He's got a sharp mind and a sharp tongue, and he's a competent, lawyer. He takes his job seriously. He's got balls, unlike the other attorneys in the room. So the transcript goes like this. The judge is like, "Oh, you were the guy I was warned about. Yeah, I heard that you actually come in here and you think this is a federal case. All right, well, you can wait till the end of the docket." You know what I mean? So he makes him wait till the end. He goes through like 20, 50 other cases in 45 minutes. And then it's time for Josh and his client. And so Josh has got all his files and everything, big box, he's ready to rock. And the judge is just looking at him like, "What are you doing?" He's like, "I'm here to try the case, Judge." He's like, "Yeah, but like, Judge," he's like, "Judge, before we begin, if I could just possibly have a table, because I see that the bank's attorney has a nice table, and I don't even have a table." This judge's courtroom doesn't even have a table for the defense. And the judge is like, "Well, here with this foreclosure mess, we can't get a courtroom for every attorney." I mean, he meant to say table, but it doesn't, he's getting pissed off, so he's not speaking clearly. Yeah, I mean, you guys don't want to hear that long story, but I mean, just trust me, it's funny as hell, because the whole trial, Josh, who's the master of like being passively aggressive, is asking for a table. And the more he asks, the angrier the judge gets. The judge tells him, listening to you talk is like, it's like throwing thumbtacks in front of a bicycle tire, eventually it's going to pop. And the judge is he absolutely loses his mind in there. And eventually, I don't know, he says, "I'm going to recuse myself," or something. And, Josh's client lives to fight another day. All right. Well, I said I was going to take questions at the hour mark. If you guys don't mind, I'd probably like to take like 3 minutes and maybe just take a leak or something. So if we could just take a brief break, that would be great. I'll be back in no more than 5 minutes.
Absolutely. Thank you.
Thanks, guys.
Outstanding, guys. Outstanding.
Getting a few new ideas. That's great.
Hey, Mark, did you figure that out for me? Thank you, co-host. Got 3 co-hosts now. Jerry, Holly. Thanks, Mark. Did you get that?
Well, yeah, you can see the difference, right?
Yeah. Thank you.
You must be on your phone again.
No, I'm on my laptop, sir.
Oh.
First time me being a host, though, so thank you all for jumping in and saving me.
Yeah, I got idea. Filing false documents, making false claims, false documents. That could stir things up quite nicely.
Yeah, that comes into what Dana and I were saying, uttering and publishing.
Mm-hmm.
I really like that he mentioned that, because the other Florida attorney group that I used briefly in my case, who wrote my active complaint right now, that when he was talking about Florida attorneys, I guess they're just aggressive down there, the foreclosure defense guys. Neil Garfield was another one. He was amazing. He did several podcasts. If I can find the links for them again, I'll share them in the group chat. He was very much against the banks. He found out what they were all doing and he started exposing them. And he was an older guy. He's passed now, but he used probably that same Florida statute, but his team that is now helping people in other states, they find your state's version of that, and one of Virginia's codes that is similar to that Florida code, that's in my active complaint now. And it's, they didn't like it, I'll just say that.
Yeah, if you can prove they're using false information, falsifying documents, well, that blows the whole thing out of the water. And if you can show they're doing it willingly and intentionally, that brings up criminal liability.
Mm-hmm.
That's what I want to get to, is how we get after these SOBs going on offense.
Yeah, absolutely. If he could dig into more what he would think is a good strategy for people who haven't even started, they're not in default. I mean, what should they do? Should they be plaintiffs and should they file suit, or should they do other things? You know, what does he think and what has he seen to be the most effective?
Hey, if you don't mind me jumping in regarding that Florida statute. So we have one here in Kansas as well that I've actually been mulling over for 2 years. I wish I had done something sooner. And mine is they even have an actual form that goes with the statute, and it's called an ex parte motion for judicial review on a document purported to create a lien. And so, I literally just filed this like, I don't know, 5 weeks ago or so, although my foreclosure and all that's already done. But I'm like, hey, what's fraud is fraud, right? And so I finally was like, I had enough knowledge, to file it. And so I copied their verbiage off, exactly as it is. And I'm sitting there thinking, now why would they have this? And you know why? Because every mortgage filed in those public records is fraud. So you know how they always have to give themselves a way out, and that's it. You know what I mean? It's like, well, here it's right here in your face. You could have done this 2 days after, after the mortgage was filed. But at any rate, in my case, I filed it. And I filed it, and the clerk gave me troubles on it, and they assigned it to a judge, a different than my foreclosure judge. And I was like, whew, good. She'll take a fresh look at it. Well, 5 days later, it gets assigned back to my foreclosure judge. And then about a week ago, I got an electronic notice in the mail that said rejected. It wasn't even a judge dismissing it, nothing. It was an electronic notice that says rejected. So these courts are just, yeah, I've never even seen a document like that, quite honestly. But yeah, every state's got it. And I would say find it and do it tomorrow. And if you want mine, I'll be happy to put it in the group. I'll just redact it. But it's just, it's literally just the document, book page number, blah, 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 which purports to create a lien, and the reasons why it's, purport, I love the word purport. They put that in a lot of statutes, because it's that presumption thing. But then you just state out why that it's a fraudulent document that's encumbering your property. So I'll be happy to put that in the group, if you guys want me to, so you could just kind of use it as a template in case you don't have something like that in your state. But anyway, yeah, it's a good one.
Thank you.
Looks like Kenneth's back.
Yeah, I was back for a few minutes, but letting her talk, and also I didn't know I had the autonomy to click my unmute button now, which I didn't have when we started. So you guys want to ask me some questions now, or you want me to continue going through the ones that I was given ahead of our meeting?
I think let's go through the ones that were given to you. And then if we have enough time, we can take the rogue. Yeah. Thanks, Ken.
Sure. I may not get to all these, but some of them I just don't either understand the question or I have no idea what to say. But if MERS is shown as inactive or not in good standing with the Secretary of State, what legal implications does that have for foreclosure authority or assignments? Probably none. At least in Florida, even though there's a statute which kind of suggests that a dissolved corporation cannot do business in the state, The courts have interpreted doing business in the state as to basically mean anything other than what they're actually doing. So whatever they're actually doing is okay, and they have the ability to do that. So, in my experience, nothing. One thing I wish I could have done or would do, maybe this is the kind of thing I can do now that I don't have to, is, calling. Like they have this 1-800 number for MERS. They have some bogus address in every state. I wouldn't mind, giving them, I wouldn't mind trolling them a little bit. Probably be a good thing to make a video and put online. A mortgage broker is cited as the lender rather than a funding entity or warehouse bank. I mean, I'm not really sure I understand that question, but like the banks that are named in your mortgage, they're not the sources. To the extent there was actually any money involved in the transaction, whether even if it was just credit, it didn't come from them. It didn't come from whatever fake bank name they put in your loan documents, because the real plan was and there are transcripts online of, there's at least one transcript of a founder of MERS. He's in my book. William Hultman, I guess is his name. And he's one of the people that really was involved in the actual founding of MERS. And he says, I mean, you could imagine the double talk that emanates from him in that transcript. But he does acknowledge in there that MERS is a bankruptcy remote entity. And what that means is that, and this is what I know and I understand reading between the lines, whatever name they put in your mortgage, your original lender, the plan was for them to all go out of business. Okay. But MERS is bankruptcy remote, meaning it's not, they can claim that the loan is with MERS, and therefore the dissolution of the company doesn't make the mortgage unenforceable. I mean, that's part of the diabolical plan behind the MERS enterprise. So yeah, I don't really know what to say about that question other than that. Law firms, liability, and containment. I don't know what containment means. Is there a lawful way to bind an entire law firm or LLP in a case so individual attorneys cannot rotate in and out to avoid accountability or suit? Well, the second half of that question is dead on, because that's what they do every single freaking time. I mean, every time you score a point, another attorney files a notice of appearance, and the first one fades away. It's that standard practice. It's the RICO enterprise. It's the badge of fraud that we all deal with, and I hope one day can be understood by the public and the government, and these people can be put in jail where they belong. But I don't know any particular way. There was a guy down in Florida that briefly had some success, an attorney down in Florida that briefly had some success challenging these attorneys because they hadn't done a notice of appearance. They would just act like they were with the same firm and come in and show up and start doing stuff. And I guess he got a couple of good results, and then I don't know, they came out with some other decision and shut that down, where they were able to keep doing that crap and without, being punished for it. Is the Walker-Todd affidavit effective in modern foreclosure defense? Well, I didn't know what that was, guys, so I looked it up. Sounds like an awesome expert witness, but it seems to me that there's one thing missing in his analysis. All these transfers of the loan are ostensibly, the bank needs to be able to say that these endorsements, that the promissory notes are negotiable instruments. Okay. That is under the UCC, that allows them to make the promissory note a holder's instrument. In other words, whoever holds it physically, it's supposed to be physically. Of course, that definition has been transmogrified into meaninglessness, but theoretically, whoever actually has the original promissory note in their possession is entitled to enforce it under the UCC if it's a negotiable instrument. And Walker Todd's testimony and his affidavits, as I understand it,
is basically saying, and this is a very rough summary, that there's no actual money involved, that it's all bullshit, smoke and mirrors, it's all credit, or it's nothing at all that's actually changing hands when there are closings on these mortgage loans. Well, it seems to me that the last step in the process to make this a really powerful argument is you need to be able to say that as a result of the fact that there was no actual money changing hands, this promissory note is not a negotiable instrument. The right to enforce it cannot be transferred by simply transferring possession or holdership of the note. And to be able to enforce it, here's the kicker: if it's not a negotiable instrument, to be able to enforce it, the bank would have to, are you ready, prove up the transaction by which the loan was acquired. Now, we all know they can't do that. They'll never be able to do that. So one of the keys to their ability to continue to get away with this enterprise, this, devastating practices that they visit upon the 99%, is this theory that the promissory note is a negotiable instrument. So if anybody's dealing with Walker Todd affidavit, from what I've seen, that's the kicker that's missing from his testimony, is that as a result of the fact that no money actually changed hands, this is not a negotiable instrument. It cannot be transferred by the endorsement alone, by being the holder. And then they have to prove, to be able to foreclose, they got to prove up the transfer by which it changed hands. And get this, they have to show consideration, guys. They have to show how much money changed hands when this note was transferred. And, they have to show good and equivalent value. So that would be what I would suggest from him. I think I already answered number 14. Okay, now we started over at number 1 for additional neutral questions for guest speaker. When a party files preliminary objections challenging standing, lack of injury, or justiciability, and opposing counsel does not respond, what is the procedurally appropriate next step for the court or the objecting party? I mean, I got to say, I don't know. I've never actually practiced in a non-judicial foreclosure state, so we don't really have preliminary objections or lack of injury. But I understand the theory. I mean, theoretically, yeah, it should be a waiver, admission, and grounds for dismissal. But if your state's anything like Florida, they're just able to, even if you get a preliminary determination or ruling in your favor, they just come back later with some excuse and get it vacated. How do courts generally view claim splitting where the same law firm files separate actions, such as a quiet title and a foreclosure action? I think generally they're going to be inclined to consolidate the cases. That also happens when a homeowner follows my favored strategy and files a separate or collateral action to quiet title or under 817 or its equivalent in your state. They might consolidate. They may, in those situations, sometimes the banks will actually ask the court to consolidate. And I think it's probably better to have a different judge. Usually in Florida foreclosure court, we got the dregs of the judiciary and assigned to the foreclosure realm because it seems like none of them wanted to do that. So when some alcoholic judge is under investigation or whatever, they would send her over to foreclosure court whenever she was in the doghouse in the 17th Judicial Circuit, which was my home judicial circuit, Broward County, Fort Lauderdale area. I don't think that there is a universal approach to claim splitting by the judiciary. I think it's a case-by-case basis. What is the legal significance of a MERS min being shown as inactive? Does an inactive min affect the ability to assign, enforce, or foreclose on the associated mortgage? In my experience, nothing having to do with MERS seems to impress the judges. They don't give a crap. They don't understand. I don't think it's going to have any real world significance. Now, what does it mean to those of us who actually understand sort of what MERS is about? And I would say that it means that, I mean, guys, the whole MERS system is a joke. I don't think it means anything. I think it's all part of the obfuscation, of the smoke and mirrors, of the this away, that away misdirection that characterizes all of their conduct. I mean, like I explained in my book, things just got curiouser and curiouser, like Alice in Wonderland, when I was having my walk through the early days of my experience in this world. Like, it was just oddity after oddity. And I think that's sort of that practice. You can see it across whenever MERS is involved. You damn sure aren't going to get any clarity, and that's all part of the plan. If the principal entity in a MERS-related transaction is defunct, dissolved, or lacks legal capacity, I remember this question. I went to town on that because it's like this. Let's say that I've got a power of attorney for my grandma, and I can make her healthcare decisions, and I can pay her bills out of her checking account while she's alive. If she dies and I keep on writing checks, am I committing a crime? Damn Skippy, damn straight. Of course, there is no authority for a non-existent principle. It defies logic to contend otherwise. I mean, it's abundantly clear that the right to operate as an agent terminates with the death or non-existence of the principal. Anybody who makes a decision contrary to that is a scumbag and is probably being paid under the table. But I know judges have ignored that. I've seen them ignore it. They've ignored it even with me as defense counsel. Somehow they want to brush by that and act like that's not a thing. How can a party obtain MERS corporate resolutions or documentation identifying individuals authorized to execute assignments? I've done a request for production about that. I've seen it once, a so-called roster, but they made it up on the spot. They didn't have a real comprehensive one. I would suggest you actually look to the deposition transcript of William Holtman, because I do believe that there is some discussion of that. And I don't remember exactly what he said, but I bet it was double talk. If a homeowner is in good standing, what essential non-belligerent steps should be taken to protect the property and establish a strong legal foundation toward allodial style ownership? Guys, you made me look up a word. I'm pretty proud of my vocabulary, but you made me look that one up. The answer, if you look at the definition of allodial, is nothing, because your property is always going to be subject to some kind of encumbrance, whether it's mostly, I mean, the one that you can't get out of at all is the city taxes or government taxes, land taxes. And allodial means not subject to any encumbrance or any interference by any outside entity. But leaving aside that technicality, thank you for teaching me a word. The only thing I could suggest again is 817 action or the equivalent, babe. That's the most powerful weapon, I think, probably in our arsenal. Or theoretically, you should be able to do just a general quiet title action, because they have committed a fraud by filing bogus documents, forged, fraudulent, and fabricated instruments in the official records, and therefore they have unclean hands. There's plenty of case law on unclean hands, and a party who has conducted themselves with unclean hands in relation to a particular contract, transaction, or business is prohibited from ever going to court and receiving any relief regarding that contract, transaction, or business in the future. Theoretically, you should be able to get a declaratory judgment from the court that before any foreclosure action is ever initiated, that they cannot foreclose. These people that were involved in this fake-ass document cannot foreclose, cannot get any relief from any court regarding it because of their unclean hands. Consideration at origination. Does an internal accounting ledger entry by a bank or servicer constitute equivalent consideration for a borrower's promissory note? No. Or is independent value transfer required to form an enforceable loan contract? I think an independent value transfer is required to enforce an enforceable loan contract. Proof of value transfer. In litigation, what documentary proof actually satisfies the court that value was transferred to the borrower?
the fact that you're living in your house, guys, in the judge's eyes, you were given this loan. You wouldn't have been able to buy this property without this loan. Wire records, funding statements, custodial confirmations, as opposed to internal balance sheet entries. I mean, those things you can definitely request, wire records, funding statements, custodial confirmations, but good luck getting them. Holder versus creditor. Explain the legal distinction between a holder of a note and a creditor entitled to enforce the underlying obligation. Remember the story about the Indian blind men holding on to different parts of the elephant and trying to describe it? I mean, that's the sort of activity you're asking me to engage in. Because, as is characteristic of these criminals that we're here about, they have intermingled, intermixed, and transmogrified the meanings of basic terms so that ultimately confusion reigns and nobody knows what the hell they're talking about or what the hell is going on. A holder theoretically should be like a debt collector or a servicer. But nowadays, somehow in the bankers' securitization, faux securitization universe, one day the same bank that was the original lender is now the servicer. Yeah, service this is my response. I mean, there's not really anything to say about that, but they have muddied the waters to the point that the distinction almost has ceased to exist. So those of us who actually speak with literal words that have an identifiable meaning in the English language would say they're two totally different things and cannot simultaneously be the same thing. I think what the banks did there was, as part of their amazing ability to confuse everything, they used those bankruptcy remote entities, the original lenders, as servicers. So whenever you challenge them later on, again, they could say that they were just the minions for whoever it is behind the curtain that you'll never ever be able to identify or pin down and deny or mitigate their responsibility and accountability. What documents actually prove that a servicer or foreclosure law firm was authorized by the principal to act? And how often do you see those agreements produced in court? Well, I'll answer the second question first. Never. I have spent my career, and I think many other badass pro se litigants and a few other competent defense attorneys have been very aggressive in seeking the retainer agreements between banks, servicers, and the law firms, and they will fight you tooth and nail, and they can rely upon attorney-client privilege to pretty much win those arguments. Again, it's whenever you try to pin down relationships. I shouldn't say again because I haven't said that before in this webinar. But in addition to the fact you can never pin down identities, you can also never pin down relationships. And that's a standard badge of fraud in their everyday business practices. Where am I? Standing at time of sale. At what precise moment must standing exist in a non-judicial foreclosure? At notice, at sale, or at deed recording? My understanding, take it with a big pile of salt since I haven't practiced in a non-judicial foreclosure state, is at the time of the notice. That's the initiation of enforcement. And I'm pretty sure it's pretty much universally the case in all areas of law that standing is determined as of the date that any kind of enforcement is initiated. And it's certainly the case in judicial foreclosure states that standing is determined as of the date the action is filed. What documents actually prove that a servicer or a foreclosure law firm was authorized by the principal to act? Okay, I guess I already answered that one. If a loan is claimed to be held by a trust, what evidence should exist to show that the loan was ever properly conveyed into the trust? And what are the legal consequences if it was not? I've sort of covered this. I mean, it goes back to the pooling and servicing agreement. That outlines the chain of custody that must be in place for this particular loan, which ostensibly they'll come to court with their, forget what they call it, the loan roster or registry. That's not the correct term, not the industry term, but whenever you get into court and you're fighting over the pooling, you're trying to use the pooling and servicing agreement. On rare occasion, the plaintiff will actually try to use the pooling and servicing agreement. they'll come in with a list of like 1,000 data points, and each one of those is supposed to show one of the mortgages or mortgage loans that was transferred into this trust. But of course, they redact all the useful information, so it's basically going to be like I don't know, 100 pages of just a lot of black marks. And, like it'll have like the amount of the loan and the zip code where the property is located. Well, that's really theoretically supposed to show to try to claim that that loan is in the trust. But guess what, guys? Those documents are prepared before the closing date. It's not like they're sitting there waiting for the promissory notes to come in and then say, oh, check this one off. It's here. This is all what you would say. I forget the term, but I must be getting tired. This is all like prospective. This is all theoretical. So when they come in with that big pile of bull crap of redaction that says, ostensibly means that your loan was transferred to this trust, that would be the proof, but it's not competent evidence because it's 90% redacted and it's a prospective. It doesn't actually reflect, it's not actually evidence that your loan was transferred to the trust. And you can usually go and look at the pooling and servicing agreement and compare it to your assignment of mortgage, and you'll see that there are entities in your assignment of mortgage that are not referenced in the pooling and servicing agreement. So that tells you right there, that's evidence that you can use to impeach their allegations, their bullshit story as to chain of custody. Timing defects. How significant is the timing of an assignment or endorsement relative to trust closing dates? Oh, it's massive. I mean, if God were the judge, you would win every case on that because of that, the significance of the closing date, which you're going to find in every pooling and servicing agreement and every servicing agreement. Now, if you think that your loan was not securitized, trust me, it was securitized. It wasn't securitized legally or legitimately, but from their side of their point of view, it was ostensibly securitized. So there is some alleged trust out there in the world that theoretically somewhere in the massive data banks of Wall Street and the Securities and Exchange Commission theoretically is the trust into which your note was securitized. That was the reason, guys, that they were approving everyone back in the early 2000s, is because they were going to just securitize they securitized some loans multiple times. Of course they did. It's like the loaves and fishes. Maybe I talked about that on my interview with Matt Cox, so I won't rehash it now. Servicer's role. Is the servicer ever a lawful enforcement party in its own right, or must it always trace authority back to a disclosed principal with a present enforceable interest? In a perfect world, of course, it's basic first year law student stuff. The servicer would be an agent of the principal, and here's a key legal point that you can use to make that argument. The agent cannot testify that the agent has authority from the principal. The only way that that authority can be proven is by a statement of the principal. That's fairly well-established law. You'll be able to find it in a Hornbook, or Hornbook lawyers are the only people that use that. I don't know what it is practically, but it's just something for, dirty jokes in law school. But the basic, legal treatise will tell you that only the testimony of the principal can establish the principal-agent relationship. And there's case law on that too in every state, I'm virtually sure. Silent principal problem, right? Same sort of issue. I've got all 50 states, LexisNexis, and all feds LexisNexis, like unlimited access, sort of by luck. Knock on wood, if I have any around here that's not fake. Oh wait, I burned it all never mind. If it's not burnt yet, it probably will be when I freeze to death here in a week, because I'm from Florida and I don't know how to handle this cold. Where was I? Yeah, so bottom line is, what was I talking about? Okay. Yeah, they should have to disclose the principal and their identity. Bankruptcy stay protection. Interaction. That got cut off for some reason. I'm sorry. Okay. Securitization versus enforcement. If a note is derecognized, I derecognize the term derecognized, then sold into a securitization structure, who in practical and legal terms becomes the party entitled to enforce, and how should that be demonstrated in a foreclosure record, if at all? I don't know, because I don't know what you mean by derecognized. Sorry, same thing for the next question. Oh yeah, I was talking about LexisNexis. So any of you guys, if you need to answer some of these questions more specifically for your state, then you can get in touch with me, and I can probably help you with law from your state on some of these more nuanced topics. Derecognition write-offs. If a loan is, I do recognize, charged off or otherwise removed as a financial asset on a balance sheet, what impact does that have to? I've had this in cases. One case I worked on, we've been waiting for like 8 months for the judge to rule after trial, but we made a big deal about that. The fact that it was charged off by, I forget who, Fifth Third Bank, and then Fifth Third, I mean, is that a thing? They're really running out of names. I always say if you multiply that together, you get like 0.166666. Is that a coincidence? I'm not sure. Kind of like Sin of Us Bank. I mean, yeah, it's the sin of us. We recognize it if nobody else does. If the trust is charged off, yeah, I mean, you should be able to defeat the foreclosure on that basis. They have repudiated their right to enforce the note, and probably repudiated anybody else's right to enforce the note when they have an entry in their ledger that says charged off. You see that a lot with second mortgages, and then somehow it seems to come back to life spontaneously. Validity of documents on their face. Is it true that courts accept assignments and affidavits at face value? Unfortunately, yes, it is. If so, what red flags should a homeowner look for that indicate the documents lack legal or factual foundation? They presented it in foreclosure court. You can pretty much guarantee it lacks a factual foundation, but I'm not going to give you a smart-ass answer like that. To give you something that'll actually be helpful, I mean, I would check the name of the person who signs it. Like I mentioned earlier, there's a, thank God for the internet, there's a pretty big subset of official records that person can access, usually for free, and you can find that person's signature on behalf of some other entity in some other capacity in some other state, and that looks totally different. And at that point, you can challenge the document's facial validity. The MERS debacle. How does MERS complicate or clarify? How does MERS complicate? Oh my gosh, all day, every day. Or clarify standing. Never happened, never will. And what legal weaknesses arise when MERS is used as a placeholder rather than a true interest holder? I mean, so far, guys, there haven't been that many legal weaknesses. My class action got thrown out. But considering the fact that we have the truth on our side, and we have, I don't know if we could get the word out, we have probably millions of determined, hardworking human beings who would like to help us expose this and invalidate all of the MERS mortgages. I think that's the way to go. I think we need to actually attack this, guys, as a movement. You know, they're asking for reparations for slavery. I say we demand reparations for all these fraudulent foreclosures that, you know, the Democrats and Republicans have let them get away with. It's just unbelievable. And, you know, if you read my book, which I did promise myself I would show you, I would put the link up here somewhere. Maybe the illustrious Miss Sawyer can help with that. The link, you can get it as an audiobook or a print book somewhere, not on Zoom. Hello. I'm not a multitasking phenom, that's for sure. It tells you in there about it, you know, how I think we can go about making a change, and why I think it is that both the Republicans and the Democrats have sold their souls to the 1%. The hard question. I think I've had more than one. The hard question. Oh, wait, let me just, I'm missing a few things here. Burden of proof. In a contested foreclosure, who bears the burden of proof? In non-judicial states, it's the borrower. In judicial states, it's the bankers. Systemic patterns of fraud. From your casework, do you see recurring structural failures? You think? Just one or two? Missing principles. You think? Undocumented servicing authority? No, never. Or trust defects? Moi? Oh, never. How often do those actually decide cases? I see them every time. How often do they actually decide cases? Regrettably, not very often. The hard question. If you had to reduce foreclosure filings today to one core legal failure, would you say it is primarily a problem of missing consideration, missing standing, or missing jurisdiction? Well, obviously it's all three, and missing standing and missing jurisdiction to me are pretty much the same thing, because if there's no standing by the plaintiff, then the court has no jurisdiction to adjudicate the controversy, because there is no actual controversy between interested parties that's being presented to the court. That's part of the Constitution. It has to be an actual case or controversy. Otherwise, the court does not have jurisdiction. Consideration is massively missing as well. That ties back into the overly complicated Uniform Commercial Code and the question of whether your promissory note is an endorsable instrument. I mean, a negotiable instrument. So with that, I think I should probably just entertain some questions from you guys.
Jerry?
Oh, I'm supposed to read. Okay.
Yeah, no.
On the allonge, is the original bank supposed to sign the note over to the assignee? Only the servicer signs the endorsement?
May
Oh,
I?
you mean like it'll
May I?
say in the stamp, it'll say as attorney in fact for the original lender?
May I?
Yes.
I could probably
Certainly,
articulate
Belinda.
it better. Hi, thank you so much for giving your time this evening for us. We're so grateful. Thank you so much. So
My
on
pleasure.
the allonge, I thought that the original bank is supposed to sign that note over to the assignee, like AKA the servicer. But on my note and others, I have only seen that the servicer's agent signed it, and it's signed without recourse. So the original bank never had like a transfer of assignment saying, okay, so and so from, let's say, Fidelity Bank has assigned this over to PennyMac. So I don't see that signing on the note. Now, doesn't the lack of the proper assignment on the note from the bank to the servicer prove that there's faulty chain of title, and it makes the note unenforceable? And that kind of speaks to what you said, that you said the principal has to be there to give the testimony, that like the servicer, they can't, it's like the fox guarding the hen house, right? So does that make sense now that I've kind of spoken out my question? And can you
Yes,
answer
it
it?
does make sense. And I would just say that your instinct is correct. The first endorsement or a launch has to be from that original lender. They have that gap in the chain of title. I think a judge will listen to that. That's pretty simple and pretty obvious, in my opinion.
Right. For all we know, and it's really, I guess, it's it has a lot of truth. So for all we know, the servicer stole this, they stamped it, and now they're trying to pass it off as, because, right? It's like
Yes.
the banker doesn't say, "Hey, I'm transferring this supposed negotiable instrument." And I think also on that note, we can also argue that, because it's like that's a weapon. Well, that's not a weapon. That's my gun. See, there's terms and words and all that, but it's not a negotiable instrument. That's a security, because Professor Richard Werner, he made the empirical study that banks do not give loans. They take deposits and they sell securities. So in my opinion, that's not a negotiable instrument. That's a security. I yield.
Thank you, Belinda. Mark has his hand raised. Mark Emery.
All right. A moment ago, Ken, you mentioned we need to start a movement, and I'm all for that. My idea is, can we find a way to bring together knowledgeable people like ourselves, including other professionals, create a website and build a staff even with some funding to help facilitate a lot of the action that's necessary. So I'm really thinking big picture instead of all these individual cases people are fighting. I'm with you. I'd really like to start a movement along these lines, and I'd be happy to contribute to that in a number of ways.
That sounds great. I think we should start a political party. Start having candidates and start, I think that will enable us to, generate publicity. I think the internet's a great tool. And, the crowd, when we get enough people to insist on something, we actually can get change to happen. We just have to get people educated. There's a lot of victims of this crap, a lot of people that are still carrying the pain and the destruction of having lost their American dream. And I think those people would get on board.
I think a political party would have to have a broad focus going beyond mortgage and banking, covering all issues. I love the idea. That could be a spin-off, perhaps, of establishing some kind of a base operation focused on the mortgages and banking. But I think we need to go after this with laser-like focus and really start cutting out the cancer wherever we find it. So
I think we could ask for reparations for victims of foreclosure fraud.
Yeah, yeah. And we have that in mind. In fact, we put together a General Assembly to act as an independent arbitration panel. And the idea is to get the opposing parties to tacitly agree to the arbitration panel, which would suck them in, and whether they appear or not, we have a finding of fact, have a hearing to have a finding of fact and law. And with that determination, which is extrajudicial, not using the courts, using the people as the hearers of the fact, and then simply start using commercial processes to establish claims and start collecting on those claims, and all that would be outside the court.
But how would you get the other side to agree to be subject to these arbitration proceedings?
Tacit agreement. Tell them this is what we're doing, and you're invited to come. And if you fail to respond, we'll take that as your acceptance.
Okay, sounds like it has potential. Who am I supposed to recognize next? Evita? Does Evita have her hand up?
Yes, I have my hand up. Hey,
All right, Evita Stern. Are you related to David Stern? I'm just joking.
Everybody asks me that. So this would probably be a little bit more controversial. There seems to be a theme when it comes to foreclosures, right? So we are going up against the lawyers and the law firms, right? And we know that they have unclean hands. They come to court, but the root of the issue is the judge. The fact that the fact that he allows this to move forward, even if you outline and you call out standing, you call out there was no injury, you call out all of these things, and he still allows it to move forward. So the issue shouldn't really be with the lawyers, right? It should be with the judge. So the moment that they violate your constitutional rights, now what would you say to a person that goes outside and now they are suing the judge in his personal capacity because a judge that kind of sways away from the Constitution is no longer considered a judge?
Well, I think that's one of the aspects of our movement that we have to address. That's one of the prongs of the oppression and the derailment of due process is that these people have immunity. It's just
Right.
like with the cops. The cops had so much immunity that they could do whatever they wanted and nobody would hold them accountable. But then with the body cams and the internet and the YouTubers and all that, finally, we're starting to see some evil cops being held accountable. And I think it's something similar where the judges have such immunity that they can, rape and pillage with impunity. And that needs to change. And I know there's been quite a bit of movement actually reducing or eliminating the immunity that was afforded, corrupt and abusive, violent police officers. And I think we need to press our elected officials to,
introduce legislation to reduce or eliminate judicial immunity.
Okay, so you say that even with all of that, the judge still has immunity.
Oh yeah, they do. I mean, I still work on cases all the time, where people are suing the judges and the lawyers involved, and I work on them as hard as I can, and I put together strong cases, but it's kind of like a Don Quixote situation, but usually the homeowner gets the benefit of the collateral litigation, putting a halt to whatever process is going on, trying to take their home or evict them or whatever. At least we get the benefit of buying more time for the homeowner. But it is a pretty difficult fight. The law is pretty overwhelmingly in favor of this judicial unqualified immunity for these bad actors that are cloaked in the false garb of legitimacy.
Thank you so much. I yield.
Okay, does somebody else have their hand up? I only have like 4 people's names on my screen, so maybe somebody else does and I can't see it.
I have a question.
Sure, go ahead.
How you doing today?
All right. Who am I speaking with? I don't have your...
This is Michael.
Okay.
It shows Brooklyn.
I know it shows a young lady there, but go right ahead, sir.
So I heard you talking about immunity, and if you know for a fact that, let's say you're in a defendant position per se, and you know that the court is not acting in a judicial capacity, but they're more like acting as a debt collector, right? So you've got evidence of Dun and Bradstreet number, the EIN. You know that there's been bonds created. CUSIP number is in play. Does that drop their immunity? Because that's what I comprehend is if you can prove that, then the judges and the people who are acting in that structure in that particular capacity doesn't have immunity.
Well, it's a complicated argument, but yes, theoretically, there is one of the few exceptions to absolute judicial immunity is if you can show that the judge is engaged in conduct that harms you, that is outside of their role as a judge. It's extrajudicial conduct. That is an exception to the judicial immunity. So I don't know about CUSIP numbers, but if you can put together a comprehensible, cogent argument that the judge is doing something that is not within the scope of their judicial authority, theoretically, that should enable you to get around judicial immunity.
Well, I have a case filed now. That's why I was really asking I was just really, because I know how to go and look for that particular information and make that particular argument, right? But I think that I think more for me it was the fact that I do have you to my disposal, and it's not very often that you get someone on your status, your stature, to really come out here and talk the way you are and give us the clues and the not legal advice. This is just opinions.
Just truth, man. Just truth.
Yeah. Equity, right? So with that said, man, I really admire you showing your face and actually coming out here to help us, and I wanted to thank you. But that answers my question, because I know how to prove that. I was in the mortgage for about 8 years as a mortgage.
Take some ass. Take some names. I hope you win. Hope you win for sure.
Do you have
I can help. I believe Mary wants to ask a question. Mary?
Yeah, can you hear me?
Yes, I can. Loud and clear.
Okay, I'm just coming behind Mike and what he's talking about, the judges and their immunity and that. I had a case that I had pulled out of state court, a foreclosure. I pulled it out September 11th, and they just continued in the state like nothing happened. And their fight was to get I'm in Illinois, so I'm in a judicial state. So if they claim to have sold your property, right, the only thing that seals that deal is a confirmation of the sale from the judge. And I did stop them for 9 months getting confirmation of the sale. Don't ask me how, because I don't know.
Okay.
As hard as I fought, I stopped them. Then in the 11th hour, I pulled it out of the state court up to federal on September 11th. Well, the docket at the state went disposed, and I learned that word from the clerk. He educated me, told me that docket is disposed. They can't.
Hi, Mary, I'll unmute you, but we need to keep this general. He's got 8 more minutes for the group, okay? Thank you. Mary, I've pushed your unmute button. You have to click it on your screen.
Oh, okay. I didn't know that. Okay, so I did. So anyway, long story short, they came in October, had ex parte meetings with the attorneys, and the judge signed 3 orders against me, and one was for possession. So what that means is, what I understand is she signed away her immunity because she worked out of jurisdiction. She operated out of jurisdiction because the docket was disposed.
I believe that's a reasonable argument. I tend to agree with you.
Yeah, so I have her in a lawsuit now in the federal, in her.
I would say that's a good argument as to her conduct being extrajudicial.
Awesome. Thank you.
Welcome. Only hand I see now is still Mary's.
All right, we have just a few more minutes. Belinda, do you want to go ahead and ask a general question?
Yes, thank you. Once again, Kenneth, thank you so much.
Oh,
So,
you're welcome.
this is almost piggybacking off of Mary's question. So, jurisdiction. I've heard that once jurisdiction is challenged, it must be addressed. It cannot just be like they can't grant themselves jurisdiction. Now, would that also be a valid reason that, like she said, now you don't have any immunity because they proceeded without, getting certification or whatever of the jurisdiction? Thank you. I yield. How does that work?
That doesn't really sound to me like a good argument, to be honest. I think Miss Lee has a question. Mr. or Miss Lee?
Yes. My question is, when I have a foreclosure sale, they did a bid rigging, and then I found the email that the plaintiff attorney sending the committee that our winning bidder, make sure write a check to the U.S. bank. Is that a good evidence to go for their sanction? Because I put the affidavit of a chill bid in the bid process, and then the email they sent it to committee, foreclosure sale committee. But judge denied my motion to vacate and fraud upon the court. So is there still, I can challenge that after the foreclosure sale? That's my question.
Thank you. I'm sorry to say I'm really not sure. I don't know I'm not familiar with a sale committee. I've never actually heard of that. I'm not suggesting that, what you're saying is incorrect, but I would need to look more into your case and to the processes in your state to give you any kind of intelligent answer on that.
Yeah, in Connecticut, it's called committee sale. It's not trust sale. It's called committee sale, foreclosure committee sale.
Yeah, I would need to read up on it and see your case to really have an idea. And again, I really can't give legal advice on particular cases, especially, in basically a public forum. Okay. I'm getting a lot of questions here about people's individual cases, and I'm not really don't have enough information. I'm not really supposed to be giving legal advice. So if you have some particular cases, I would just suggest you reach out to me. I know Miss Sawyer can give out my contact information. I mean, you can find me online. I'm an open book. I'm not a sneaky false identity type person like so many of our enemies in this disgusting affair. If it's okay with you guys, I guess we will call this. Well, I don't know. What else would you like to do, Miss Sawyer, before we conclude?
Well, Ken, I would like to. Can you hear me, Ken?
Yes, absolutely.
Okay. This is Tammy, and I would like to ask for the group, our I already am connection with you, so we would like to have maybe a consultation one-on-one with my groups individually. How do you want to be contacted? Through
I mean,
me?
you can give my number to your group
Sure.
members. I know everybody here is
Okay.
good people, legitimate people that need help.
Yep.
I'm here. I'm available.
Perfect. Okay. Yeah, we're gonna end the questions right now because, we thank you, Ken.
Well, thank you. Thank you so much for having me.
Glad
Anybody
I
wants to get my
found you.
book, I would appreciate it. I think hopefully she's given you the link, or I can, to get it on Amazon.
Ken, I've put a link to your book in the chat. I can put it in there again for anyone
All
that
right,
missed it.
great.
It kind of got buried a little bit.
Yeah, it did get buried. I'm glad there's participation anyway. Participation and interest is always good. You guys stay safe as well. I wish we had a foreclosure freeze instead of a general freeze. We
Yeah.
did actually have one back in 2010 when my lawsuit hit the news, but it didn't last long. You know how they are. God bless you all. I sincerely wish you the best.
Yeah.
Keep up the fight, and let's make some changes in this disgusting and corrupt realm.
We
Let's make
will.
America a better place. Really.
Absolutely. And if we can close with a prayer, Ken.
Absolutely.
Mark, can you close the prayer? Close with a prayer, please.
If I can get unmuted, I will. All
God will
right.
hear you.
Heavenly Father, thank you for bringing us together, for showing us the light on the fraud and the deception that's going on, that is oppressing your people. Lord, we stand in faith and on truth and righteousness, that we will stand strong, giving all glory to your holy name for pushing back on this darkness, and that we might simply do your will in helping to build your kingdom, and that each of us is doing our part in the process, that we can work cohesively as a team, put aside our petty differences, and come together cohesively to form a force that simply cannot be stopped due to the presence of your Holy Spirit. In Jesus' name we pray. Amen.
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 Thank you so much, guys.
Thank you, Ken.
God bless
Thank
you.
you, Ken.
God bless.
Thank you.
Stay
Thank you.
safe. God bless.
Bye-bye. Thank you, everybody. I'm going to stop record.
Thanks, everyone. Have an excellent weekend.
You guys too. Stay
Thanks,
safe.
guys.